Hello friends, congratulations, your divorce is finally over. As you embark upon this new chapter of your life with your children, you may all of a sudden come to the realization that you now have to move either out of the city that you live in, out of state, or even out of the country. Oh no, what do? Well, we've got you covered. Today is the first of a 3-part series on relocation after divorce. Welcome back to the Divorce Broadcast. My name is Manny Segarra, coming to you from Miami, Florida. So let's go over some of the reasons that people may want to either move or relocate after a divorce. There are a variety of reasons why this may happen, but we'll try to review some of the more common ones, starting with new job or career opportunities. Specifically, at the time of a divorce, a spouse may not be working or may be in a completely different career. As time goes on, maybe they got more education or training, or maybe a job opportunity opened up and they want to pursue a different job in a different city, a state, or even in a different country. Number 2, there may be a remarriage after the divorce. People sometimes get remarried. I am not going to comment on whether or not that's a good idea, as that is a video for another day. But if they get remarried, they may want to follow or move and live where their new spouse lives. Number 3 has to do with economic circumstances. As all of you know, the price of housing throughout this country has risen dramatically. In some of the major cities, rents have skyrocketed, and being able to obtain a mortgage is something that is untouchable. Because of economic reasons, sometimes people want to move to other parts of the country that have a little bit more reasonable standard of living and are more affordable to live in. Number 4, and this may have to do with the children. Perhaps the children after the divorce develop a special skill or sport. This can include children who either are training for the Olympics. Perhaps they are really good at one of the 4 major sports like football, baseball, basketball, or hockey, maybe even soccer. And maybe in order for them to continue to develop their skills, they may have to live in a different part of the country where some of the better schools at these particular sports may be located. The 5th reason would be because of an unexpected illness or death in the family. One of their parents, or maybe a sibling, or maybe someone who's disabled or has some sort of disability. That person may wish to relocate so that they can be there and be the caretaker for that family member. And finally, one of the other issues that comes up, someone may want to move so that they can be there with their support system or their extended family. I have a sister that lives in my hometown of Chicago. I wish I could spend more time with her. It is natural for you to want to be there and hang out with your family. So if you have a strong support system and family that you want to move to and you're here alone, that may also be a reason for you to want to relocate post-divorce. All right, I thought it may be a good idea in this first of our 3-part series to explain or go over some of the definitions and or the logistics of the Florida Relocation Statute 61.13001. That statute sets forth a lot of different definitions, one of which is defining the word parent. According to the relocation statute, a parent means any person so named by a court order or express written agreement who is subject to court enforcement, or a person reflected as a parent on a birth certificate and who is entitled to access to or time sharing with the child, which is subject to the court's determination of relocation. The statute also defines what relocation means, and I'm going to read to you what the statute says. It's a little bit wordy, so bear with me because I'll try to explain after I read the definition. So, relocation means a change in the location of the principal residence of a parent from his or her principal place of residence at the time of the last order establishing or modifying timesharing, or at the time of the filing of the pending action to establish or modify timesharing. The change of the location must be at least 50 miles from that said residence, and for at least 60 days, not including a temporary absence from the principal residence for purposes of vacation, education, or to provide health care to that particular child. So I told you it's wordy. Let me break it down for you a little bit better. It essentially means the parent moving from their current residence to a different residence that is farther than 50 miles away and that is longer than 60 days, not attributable to a vacation, either educational pursuits or an illness to the child that needs medical attention outside of the 50-mile radius. So I hope that helps in terms of breaking down what relocation in the particular statute is defined as. Let's now move on to some of the logistics in relocation cases. If by chance there's an agreement, relocation by agreement must be written. It must reflect consent of the other parent who has custody rights. It has to define the access and time sharing that the non-relocating parent has. And it must be approved by a court order. Now, if there's an agreement, you don't have to litigate it. You can probably go to the court's motions calendar or submit it together as an agreed order. However, unfortunately, relocation cases are the cases that are one of the most litigious because it is completely understandable that one parent has a legitimate reason to leave. However, the other parent faces the fact that they may not have the day-to-day or as often companionship with the child. If there's no agreement regarding the petition to relocate, then the parent wishing to relocate has to file a petition for relocation with child or children. In that petition, there are certain components that must be written into the petition. The first of which is the description of the location of the intended new residence, including the state, city, and the physical address if it is known. 2, the mailing address. If it is different than the physical address, the mailing address needs to be in there. 3, the home telephone number. Obviously, the statute's a little bit dated because everyone has cell phone numbers now. But if there's a home number, put the home number in there. If there's a cell number, put the cell number in there. Number 4, the date of the intended move or the proposed relocation. Number 5, a detailed statement of the specific reasons for the move. And here's an interesting one. If one of the reasons is based upon a new job offer that has been reduced into writing, then it is necessary for that written job offer to be attached as an exhibit to the petition that you're filing for relocation. The next provision required in the petition is extremely important because it requires that the petition contain a proposed, revised post-relocation time-sharing schedule together with a proposal for transportation arrangements so that time-sharing can continue to take place. It is a very important provision because unless there is an order either abating, restricting, or terminating time-sharing by the other parent, if this particular provision is not in the petition, then the court will find that it is legally insufficient and it may get dismissed. In addition to that, it is a very unique statute in that the petition has a little caveat that says there's a section that has to have something in all caps. We're going to put a link so that you can see what has to be all capped, but essentially in the petition in all caps and in the same font or even a bigger font, it must state that the person objecting to the relocation has 20 days to respond, and if they fail to timely object to the relocation will be allowed unless it's not in the child's best interest without any further hearing. So that's why it's captioned and that's why it's big. Remember, once all of these requirements are in the petition to relocate with child or children, it gets filed and it must be served on the other parent and anyone else that is entitled to access to and time sharing with the child in question. So as we wrap up Part 1 of 3 of our relocation after the divorce series. As I mentioned before, these are some of the more difficult cases. So if you know anyone who is contemplating moving or relocating with their children, have them look us up at www.segarralawfirm.com. We have offices in Miami and Orlando, Florida. Se habla español. Please do us a favor and like this video and share this video with anybody who's thinking about moving for that new job opportunity or whatever event their new life has presented to them.